I'm Ben Meiselas from the MeidasTouch network. A very important oral argument was held before the D.C. Circuit Court of Appeals regarding a very important and potent charge that is being used and has been used by the Department of Justice to hold insurrectionists accountable. And the insurrectionists have been doing all they can to try to defeat this charge or to claim that the charge is being misapplied to them. And the charge I'm talking about is obstruction of an official proceeding, which is found at 18 U.S. Code Section 512C. Now, this oral argument relating to a challenge to the way the Department of Justice has applied 18 U.S.C. Section 1512C is the second major challenge to come before the D.C. Circuit Court of Appeals. You'll recall another update that we did about a month or so ago where the D.C. Circuit Court of Appeals on a separate issue relating to the same statutory text but different words within the statutory text, the D.C. Circuit Court of Appeal ultimately ruled that the Department of Justice had the right to bring these obstruction of official proceeding charges in that context. I'll talk about that in just a moment. And here, different words within the statute were challenged by the criminal defendant in this matter. It was someone by the name of Thomas Robertson, who was a former cop who went to the January 6th insurrection and took a deadly weapon and attacked Capitol police officers and was ultimately sentenced to 7 years. This obstruction of official proceeding actually carries with it a 20-year prison sentence. And let me just read for you the statutory text, and then let me explain to you what these insurrectionists are doing to try to challenge it, but ultimately why the Department of Justice has prevailed and why I think they will continue to prevail. So 18 U.S.C. Section 1512C states the following: whoever corruptly, 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. So in the first appeal that went before the D.C. Circuit Court of Appeals, the lower court, the trial judge, who was named Judge Carl Nichols, ruled that 18 U.S.C. Section 1512C only applies where an insurrectionist alters, destroys, mutilates, or conceals a record or document. And that part 2 of the statute that I just read you, which says otherwise obstructs, influences, or impedes, still has to relate to subsection 1, which deals with records or documents. In other words, if an insurrectionist did not intend to and actually destroy records and documents, according to this Trump-appointed federal judge, Judge Carl Nichols, you cannot charge that individual with obstruction of an official proceeding. You could charge them with other crimes, just not that very powerful charge which carried with it a 20-year prison sentence. So that case went on appeal, and last month a 3-judge panel, which consisted of Judge Gregory Katsas, a Trump appointee, Judge Justin Walker, a Trump appointee, and Justice Florence Pan, a Biden appointee, in a split decision, a 2-to-1 decision with Pan and Walker in the majority and Gregory Katsas in the dissent, ruled that based on this statute, subsection 2 is its own section, that the word or actually means or. So if an insurrectionist obstructs, influences, or impedes any official proceeding or attempts to do so, regardless, like if they ripped up a document or destroyed a record or anything like that, they could be held criminally liable under the statute and imprisoned for not more than 20 years. The otherwise obstruct, influence, impede any official proceeding or attempt to do so is its own independent basis, in other words, from which to charge an insurrectionist. And they said or means or. The 2-to-1 majority did there. So that was a win for the Department of Justice because Judge Carl Nichols, the Trump appointee, actually ruled that the motion to dismiss filed by these very violent insurrectionists in that case, and we're talking about some of the worst insurrectionists who were before Judge Carl Nichols, he granted their motion to dismiss on that obstruction of official proceeding charge. The other charges that the DOJ brought were able to proceed, but that one, which carried with it the heavy prison sentence, was not able to proceed. Okay, so now there was a second appeal that was brought, and the second appeal was brought by this Thomas Robertson, but many other insurrectionists had made this same argument as well, and it didn't relate to the subsection C2. It related to the word corruptly. So if you look at the statute, it says whoever corruptly, 1, alters, destroys, mutilates, or conceals a record or document, or 2, otherwise obstruct, influence, or impedes any official proceeding or attempt to do so. So here, Thomas Robertson, the insurrection, said, fine, even if subsection C2 provides an independent basis for criminal liability, the obstruct, influence, or impede official proceeding, the word corruptly should be defined very narrowly. And the way corruptly should be defined here, according to the insurrectionist and Thomas Robertson, corruptly should mean for the benefit of Donald Trump and in service of Donald Trump. That's what corruptly should mean. It should have a narrow term. And the Department of Justice was like, why are you giving it that narrow term? Corruptly means the basic definition of corrupt, to act unlawfully with respect to otherwise obstructing, influence, or impeding any official proceeding or attempting to do so. A broader, more common sense reading of the word corruptly, as opposed to this kind of manufactured definition of corruptly, which has to be linked to the Department of Justice showing the direct link in aid or service of Donald Trump. 3-judge panel here as well. You had Justice Pan, who wrote for the majority in the other decision that I talked about earlier in this video, who's, again, a Biden appointee. You had Judge Cornelia Pillard, who is an Obama appointee. And then you had Justice Karen Henderson, who was a George H.W. Bush appointee. So that's your 3-judge panel there. And here, Judge Henderson, who appeared to be in the minority, she is the right-wing justice on that 3-judge panel, made a point that the majority would seem to have this broader interpretation, essentially meaning that, again, this will be a 2-to-1 decision in favor of the Department of Justice's interpretation and not this very kind of strained and manufactured reading of very basic language and very basic words here. So based on the full oral argument here, we fully expect the Department of Justice to prevail. It will likely come out as a 2-to-1 decision. We don't have the order yet, but I would expect to get the order fairly soon, with Justice Pan and Justice Pillard in the majority, Justice Henderson in the minority, writing the dissent here, a 2-to-1 decision. But the overall takeaway is this would allow the obstruction of official proceeding to continue to be used by the Department of Justice. And again, this is where a lot of the heavy prison sentences with respect to the insurrectionists are utilizing this statute, 18 U.S.C. Section 1512C. And finally, the last point I will leave you with, as we did that statutory analysis, is that I don't know what you think. I mean, to me, the wording is very clear here. And or means or to me, or in the alternative, subsection 2. And I don't see why corruptly should be given some other definition that doesn't exist, where the word corruptly kind of means what it sounds like here. But you see the kind of attacks that are used by the insurrectionists to try to overturn these sentences. And to me, it's so bizarre to even see these right-wing justices like Gregory Katsas or Karen Henderson come up with these bizarre conclusions to help the insurrectionists, where it's a very clear statute that we're all reading and that I just broke down for you. But a big important day for the Department of Justice in that oral argument. Again, another big win. But you just see the type of legal skirmishes and how it's analyzed. Just want to go through that with you. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. It's free to subscribe to our YouTube channel, so just hit the subscribe button. Also, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. Become a member at our Patreon. No worries if you can't. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast as well. That is free. Hit subscribe on our YouTube channel. It is free. And thank you so much for watching, and have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.